Welcome to Employee Termination Tips. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we'll be discussing certain key misconceptions of termination letters. Now, the first misconception that we're going to address is that these letters set out a fair arrangement for the fired employee. And what they are not is necessarily fair. What they are is a form of legal protection and cover for the employer. They are setting out only that information which the employer wants to disclose or which their lawyer is allowing them to disclose. And as such, they are very formulaic. And you can tell how formulaic they are in many respects because oftentimes the entire letter, if read very carefully, will be shown to be a letter that's designed for another jurisdiction. What I'm meaning, it was drafted, the basis of the letter was drafted for one province, but is now being used in another province. And because it provides certain protections, it limits the amount of information, including not providing any reasons for the person's firing, and setting in very limited structure how the calculations are made. It is designed to protect the employer and has little to do with advancing any situation for the employee, which makes perfect sense given that the employer does not want to give their employee or former employee any legal ammunition to go after them. So it's minimalist at best. Secondly, the calculations that are put forth in the letter are easy and straightforward. They may seem relatively straightforward because they throw single numbers. They talk about the termination pay, which is somewhat formulaic. The question is, are you using the right formulas? But as soon as you pass beyond termination pay in lieu of notice, and you look at all the other numbers that need to be addressed, if they are even addressed in the termination letter, those numbers create increased complexity. And whereas they may very well be straightforward, if there was only a contractual arrangement that dictates the employer-employee arrangement, the situation in Canada, even more so than in the United States, is that there are very strong statutory provisions which create specific protections for the employee, which in truth are not necessarily continually followed. Because once again, the formulaic process, the difficulties associated with it, the lack of challenge by employees, the difficulty of discerning this information, and wherever these situations arise, the fact of the matter is that when you discern new information, it typically works against the employer in the sense that it would cause payments to be elevated, increased to the employee. And if in truth they were increased against one employee who's been terminated, they would necessarily have to be applied to all employees of that particular company. And for that very reason, this additional cost, which the employer naturally does not want to take on, is not pursued. So what they do is they fall back to very simplified mathematical calculations, which are not necessarily consistent with the laws, whether statutory or common law. But since most people believe, and if they look at the internet, they see the simplification of all numbers and arithmetic formulas. And unfortunately, that is not how we work. We don't work on simplicity that is shown on the internet. Instead, you got to work on sophistication and specificity that is set out in the law, and most specifically in statute, including employment standards laws. That is critical. Number 3, it sets out all aspects of pay due to fired employees. What it doesn't do is that in most circumstances. In most circumstances, it provides one or two singular numbers. And it often defers the mention of other numbers until after you have received that requisite paycheck. And this gets tied into timings for accepting these termination letter offers and signing releases and everything else, in that they provide you possibly two, sometimes only one number. They might provide you the termination pay in lieu number, and they might provide you a lump sum number. And that lump sum may or may not include the other outstanding pay that you're due, because you have accrued vacation pay that's going to be coming due. You might well have back pay that's due. You might have other outstanding payments that are due to yourself. There is lots of consideration there. And a lot of it is pushed on effectively by manipulating the statutory time periods, which have been extended. Even in Alberta, they've now extended out the statutory time periods within which these final payments need to be remitted to the employees, so they don't even see or know fully what those numbers are. They're sort of left to chance, left to see the numbers that are there, and they're left at their own discretion. And unfortunately, what also happens is that far too many employees, when they're terminated, don't pull up their payroll statements and scrutinize them as against their termination package, because it's actually somewhat difficult to do. There's complexity there. But when you only have one or two numbers and you don't have any proper breakdown, it makes it difficult to associate one with the other and know what's actually applicable. Number 4, the employee termination letter calculates severance pay so as to legally pay the fired employee all that is due. So as we've talked about in other videos, as you might well know, termination pay in lieu of notice is the statutory minimum with respect to one type of pay, and that's your exit pay. It's not an all-encompassing pay. It's a payment that's due when you are asked to leave and you are not provided a working notice period. And this is the minimum. But beyond the minimum, common law can dictate, not based on length of service by itself, but by other conditions, including the capacity to be reemployed, that you are due a greater amount than termination pay in lieu of notice, which is severance pay. And that severance pay is something more, dictated by common law, multiple factors. But there's no breakdown that's almost ever provided in these termination letters as to how it's been calculated. That's an internal process. And oftentimes that too is lumped together with other components that makes it very difficult to scrutinize. But not only does it make it very difficult to scrutinize, it also creates the belief that these are the only two payments that are due, or possibly there is a vacation pay payment that's due. And it attempts to limit the employees in what they're pursuing or observing, because they're focusing on these numbers as opposed to any other numbers. And that is problematic, in that there is the potential for other pay to be due. Because as we talked about earlier in this video, we indicated that a lot of payroll, a lot of employment decisions and calculations and pay structuring is derived from other provinces, other than the province within which the employees are working. This is very similar with payroll. So what happens all too often is there's the potential for back pay to be outstanding and owing to the employee. But for the fact that they haven't scrutinized it before, they're not going to actually scrutinize it then because it's going to challenge their position. But now they have an opportunity to scrutinize it, but they got artificial timelines that are being produced, demands for release letters, suggestions that you're not going to get your money if you don't sign off on this paperwork fast. Very challenging time. This is when you need to engage with knowledgeable legal counsel and determine this stuff. Because you could be leaving, once again, significant money on the table. And this is earned money. It's not money that they're just willy-nilly giving out. It's what we're talking about. There's earned money. Number 5, the employment termination letter that your boss puts forward to you now seeks to quote your past employment contract, whether the original one or some subsequent one, which had distinct limitations as to your rights and the payment amounts. And because of that, you have to accept these lesser rights and lesser payment amounts because you signed off on them in the first place, or you signed off on them during the course of your employment. Now, the problem with this is, first of all, they can't be below the minimum standards of employment standards legislation in your province. Doesn't matter what happens in any other province, especially with these larger multinational corporations or multi-provincial corporations. They often have one standard employment agreement, they have one standard employment termination agreement, so on and so forth. And there's a lot of transgression of laws that are not specific to one jurisdiction, because especially with employment standards legislation and the laws from province to province, they do change significantly. At least when it comes to certain calculations that can significantly impact the termination package and the exit money that you're supposed to receive. Furthermore, employment agreements are viewed with some level of scrutiny by the court because they reflect the power imbalance between the employer and the employee. The employer is offering up the job, but they set terms that they can dictate because of their power imbalance. And the courts recognize that. So if you're inconsistent with the way the laws are, and especially there's parts of those employment contracts that are either violating employment standards legislation or making changes during the course of the employment without giving appropriate compensation for those changes, the entire contract can be voided. Not going to be in all circumstances, but in certain circumstances it can be. You can look to case law for this. And because of that, then you can open yourself up to greater amounts of severance pay. Because oftentimes what is attempted to be done in these employment contracts is they attempt to limit the amount of severance pay by contract. But if the contract is negated, there is no holdback or no restriction on the amount of severance pay that's due. And instead, you're left to look at common law, judge-made law, precedent for doing that. Number 6 on the misconceptions. You need to meet the time limits set out in the letter, or you have the potential to lose all the opportunity and money that is coming from this letter. Now, first of all, termination pay in lieu of notice, vacation pay that's outstanding, those are controlled by statute. They're not controlled by any letter. There's specific time frames within which they need to be paid, and there's really no basis upon which an employer should be holding that money back. Now, the additional payments with respect to severance pay, yes, you can get it quicker, but if it's not right, why should you have to hold back? Just because you don't take it now doesn't mean you can not get it later. One of the things you can do is you can ask for an extension of time so you can properly scrutinize it, with a lawyer. There's nothing that says 7 days or 14 days is all that you're allowed. If you ask your employer for that additional time so you can make the proper arrangements, talk with legal counsel, especially what I always love is when people get terminated right before vacation and being like Christmas holidays, and they're expected to not only get through the fact that they lost their job right before the Christmas holidays, but during the Christmas holidays, they're supposed to find a lawyer, get everything properly assessed, negotiate with the employer, and so on and so forth. Completely ridiculous, but that's what you see. But beyond that, time limits are artificial creations. They're designed in most part to get this process moving and to get stuff finalized in a quick and efficient manner, also to the benefit of the employer. The employers have realized that they can't have you sign when you're in the room the package, so that to give you some time, but they don't want to give you too much time, because you get too much time, people either procrastinate or they take the time to properly educate themselves and engage with legal counsel. So they're trying to balance it off to their best advantage. But there's the time restrictions. Yes, if they got a good offer on the table, you might want to take it because it's there and you don't want to engage with stuff. Well, then proceed accordingly. Move quickly. Start talking with a lawyer. Get them all the materials. Review it to make your determination. You've always got more than enough time to do that. In truth, a lot of this stuff over here for myself can ascertain if there's something to proceed with very quickly. But you need to have the materials and you need to engage quickly. And number 7, if you don't sign the release that they provide you with, you won't get your termination pay. Once again, termination pay, accrued vacation pay, other earned pay, that money is all required to be paid irrespective of you signing a release or not. The release is only related, in truth, to severance pay, which is the common law part, which you could arguably be fighting over. It also tends to relate to back pay, but nobody really talks about it that way because back pay has not been paid as of yet, so it hasn't been subject to negotiation. But if you take the time to read through the release agreement, you will notice that the release talks about all obligations of the employer to pay the employee have been fulfilled. And that is an attempt, although in most jurisdictions it is not final, but it's a very effective first step in the process to contend that there is no back pay owing. And that is why you got to be cautious with respect to signing releases, because that's the first argument that the employer is going to take. Irrespective of that, what you need to understand is that the release only pertains to aspects of some degree of dispute. If you take the money now, you have to sign off on the release, yes. But if you don't sign off on the release and you're engaged with a lawyer and you're talking about this with the employer and the employer's lawyers, you're still entitled to all your earned salary that you were going to get on your normal paycheck to the last day. You're still entitled to termination pay in lieu of notice. And you're still entitled to your accrued vacation pay. And that's all due in accordance with the timelines set forth by the statute and not by anything the employer says. As the other payments, those things can take time to be argued, take time to be litigated. But this is what we're talking about. Whether it's severance pay, which is your ability based on your situation to find new employment and payment that is designed by legal precedent and judge-made law or common law, as well as the potential for back pay. And as you might learn through our videos and through scrutinizing them, depending upon the jurisdiction that you operate in, back pay can be quite significant. Because what we have found is there's an over-reliance upon simplified systems. Everything is going to consistently simpler and simplified, centralized, and uniform. And the problem with pay arrangements and even with termination pay and severance pay is they're not talking about uniformity. There is not this kind of uniformity that some employers would like to believe and some lawyers would like to believe. It is a complex situation, made more complex by the fact that every province has its own set of employment standards, legislation, and mathematical computations for everything. Different factors, different numbers get inputted. And on top of that, you have the Canada Labour Code, and the Canada Labour Code pertains to those companies, and they're specific companies, that have a multi-provincial scope to them and are covered by the code. And what creates that complexity, added complexity, is the fact that even though your company might be operating largely in Ontario, or you might be employed in Ontario, if you are subject to the Canada Labour Code, all pay determinations are determined on the arrangements and the calculations that are drawn from the Canada Labour Code and not the Ontario Employment Standards Act. And the same applies to somebody who's employed in Alberta but is subject to Canada Labour Code. There again, you have to look to the Canada Labour Code for how your pay statements are developed, how your calculations are developed, and what's required of you. And what we see is all too often is a failure to recognize this key issue. And it's very clear to ourselves because we looked at it for so long, but it's not necessarily apparent to a lot of people that pay statements are not structured in accordance with the specific laws. There are aspects that are addressed, but there are other clear aspects that are not addressed and not specific. And instead, a uniform system is proceeded with, and what it does is it effectively saves employers significant money. But it undercuts the employee with respect to money that they are owed, and this is money that they've earned and they're entitled to legally. It's not some wishy-washy conceptualization as to why you do something. This is hard realities of mathematical formulas that are being misapplied or misused, and it's costing employees such as yourself, especially those who have been fired, for money that they are owed and now they are in great need of. So when you take a look at your termination letter, scrutinize it, speak with a lawyer about it, spend significant time trying to address what's contained in it, because you'll be surprised at how much is missing from it, how much is misconstrued once you finally get down to looking at it, and how it's really designed as a means to protect the employer and to reduce their costs and avoid paying you all that you might well be due. Thank you.